rise and come to order. The Supreme Court of Guam is now in session. The Honorable Chief Justice Robert J. Torres presiding.
You may be seated. Good morning, councils.
Good morning.
Will the clerk please call the case?
This is Supreme Court case number WRM 10-003. Carl T.C. Gutierrez and Frank B. Uggan Jr. petitioners versus the Guam Election Commission, Joseph Mesa, Martha Ruth, John Titano, Alice Tyron, John Chalai, Joshua Tenorio, and Robert Cruz respondents, Edward B. Calvo, and Raymond Tenorio, real parties and interests for oral arguments. Appearing for petitioners, Carl T.C. Gutierrez and Frank B. Uggan Jr. is Attorney David Lujan, Attorney Ignacio Agagi, Attorney Dorian Weinberg, and Attorney Delia Lujan. Appearing for respondents, the Guam Election Commission et al. Is Attorney Roland Mantanonia and Attorney Cabot. Appearing for real parties and interests, Edward B. Calvo and Raymond Tenorio is Attorney Michael Phillips and Attorney Ricardo Cordallo. Before the panel is Chief Justice Robert Torres, Justice Catherine A. Merriman, Justice Pro Tem Miguel Gamapan. Your Honor, Attorney David Lujan reserves 15 minutes.
All right. You may proceed, Mr. Lujan.
I'm sorry.
You may proceed.
Mr. Weinberg will handle the first part.
Okay, Mr. Weinberg. Welcome to Guam. Welcome to our court.
Thank you, Your Honor, and thank you to the court for permitting me to appear to argue in this matter. Your Honors, Mr. Lujan has indicated, reserved time for rebuttal, and it is anticipated that the main aspect of his rebuttal address will touch on the issue of de facto officers, and which we anticipate will be raised as a significant defense by the petitioner. So I would like to address a number of other issues, to be specific, the following. First, the propriety of a petition for writ of mandate or the alternative prohibition under the facts and circumstances of this case. Secondly, the scope of the remedy that petitioners seek. Third, the impact of that remedy on this and other matters. Fourth, the relationship between this petition and other pending actions. Fifth, the notion of laches as raised by the respondents. And finally, the issue of harmless error, also raised by the respondents. First, with respect to the propriety of the writ under the circumstances of this case. What petitioners have presented to this court by sworn declaration, by public records, and by admissions from the Guam Election Commission is a situation in which not one of the sitting members of the Guam Election Commission was, as of November 2, 2010, legally appointed. Every single one was there contrary to the requirements of the law.
Is there any evidence, though, that the members were not appointed by duly passed resolution of the party? I know there's a statement that the letter came from the chairperson of the party, but is there any evidence in the record to show that the chairperson of the party wasn't acting on a duly passed resolution?
Your Honor, as we have indicated and is made clear by the excerpts submitted in the declarations of Paula Branch, our search of the official records of the GEC have revealed that there are no resolutions on file and no evidence of resolutions with respect to all 6 of the members who were supposed to be nominated based on a duly passed resolution. There are records of other earlier resolutions with respect to 1 or 2 of the candidates of the commissioners, and with respect to other commissioners in the past. But with respect to the 6 commissioners other than Mr. Cruz, who were sitting on November 2, 2010, there is no evidence, and the GEC has agreed that there is no evidence that they were appointed following a nomination based on a duly passed resolution. And of course, respondents have not presented anything to the contrary. So the court has before it official records that show the absence of the duly passed resolutions that the law requires. And as to three of the commissioners, that is Meza, Ruth, and Cruz, their terms have clearly expired. In the case of Mr. Meza, by more than 2 years. In the case of Mr. Cruz, by more than a year. And I think Mr. Lujan will address the issue of the function of the oath, when the oath is taken on the issue of the length of term and whether or not Ms. Ruth in particular was still serving her 2-year term as of November 2010. But the point that we raise and the showing that we have made and the fundamental issue presented to this court is you have an entire commission, 7 members out of 7, who were not duly appointed according to law. That's not a simple technicality. It's not an error that affects 1 or 2. Every single one, the entire commission was tainted. We believe that clearly under those circumstances, action is warranted by this court, and that a petition for writ of mandate or an alternative prohibition is plainly the appropriate remedy. Now, respondents protest that we haven't met the conditions of relief.
Counsel,
Yes.
in fact, they are not de jure members.
I'm sorry.
Should we consider them as de facto members?
This is precisely the issue that Mr. Lujan intends to address, but the short answer is that under the circumstances of this case, they cannot be considered de facto members because of the pervasiveness of the disregard for the law sufficient to call into question the good faith of the entire process. And when good faith is called into question, the de facto officer doctrine does not apply. But with the permission of the court, I'd like to defer that argument to Mr. Lujan.
But let me ask this, you're not asserting that the board exceeded the power that was vested in it in their office de jure, right? So if they were de jure members, they clearly have authority under the statute to issue, to certify the election and issue certificates of election.
If they were de jure members, of course, they would have had exactly the powers that they exercised here, but they were neither de jure nor do we believe under the circumstances of this case de facto.
But you've made no allegations that they were unfair or engaged in fraud or some sort of misconduct or bad faith in undertaking any post-election actions and procedures, right?
We have made the allegation that they made decisions on how votes should be counted and tabulated, which decisions are of great importance and should not have been made by officers not duly appointed and not legitimately in office.
But you haven't made allegations that they exercised bad faith or abused their discretion in making those decisions.
We have raised the issue of good faith and bad faith in the selection and appointment process. The question of the actual vote tabulation, how that was done, and the decisions that were made is an election challenge. We are not making an election challenge. This is not an election challenge under 12102.
I think we're mindful of the fact that you're not purporting to directly contest the voting itself. But instead what you're saying is that you're challenging the post-election actions and decisions of the GBC in what was a very close race. But nevertheless, isn't such a challenge simply an election challenge, and what you do have is just a wolf in sheep's clothing? It's in essence an election challenge.
It's not, Your Honor, because, you know, if we look at the actual legal principles involved and the actual legal directives, Title III of the Code, Section 12102, sets out 6 specific grounds for an election challenge. No one can realistically assert that what we are doing fits any of those grounds. We are raising something structural. We are not objecting to the way the election was handled, nor are we in this proceeding challenging the way the votes were counted. What we are raising is a structural defect in the process, which this court cannot ignore. This court cannot ignore the fact that for the last 2 or 3 years, no one has followed the dictates of the law in the selection and appointment of the members of the Law Election Commission. That is a pervasive problem. That is completely different from the 6 specific grounds that are set out in 12102 and which we have raised in the district court and in the Law Superior Court. Those are separate actions. They are viable, they are independent, and contrary to respondents' suggestion, nothing that is intended by this action abandons or undermines those actions. They are independently vital, independently viable. However, if the court takes the action that we think is appropriate in this matter, then those other actions will be unnecessary. We will instead have what we believe to be a legitimate count of the votes by a legitimate body. And let me emphasize this.
But if you file it, there is pending an election contest in the Superior Court 1.
It is pending.
Right. And so under our election code, specifically 3 GCA 12115, it talks about the court in an election case to be able to hear all issues which arise in the contested elections. So doesn't it seem like it permits the court to be able to hear this issue as well once the election contest has been filed in the court?
Let me say this. First of all, I think if you look at 12102 and 12105, which identify the matters that can be and should be brought in the Superior Court, I don't think they include what we are raising here. But if they arguably do, that raises simply a different question of should we have started in the Superior Court? And that is a matter that is clearly and decisively answered in Underwood and in this court's December 23rd order. This is a matter of great public concern which requires speedy resolution. Going to the Superior Court, even on November 19th, even if we could have, would not have been the speed, the remedy that a matter of this importance requires. This court agreed with that in its December 23rd order by recognizing the importance of the question, recognizing that it's a matter of great public concern, and recognizing that it requires to be expedited. Underwood makes that exact point. So even if this court were to decide, and I believe that it is not the case, but that under 12115, this matter could have been raised in the Superior Court, or it could have been raised in the Superior Court by an independent writ mandate, which is also, that is true. Nonetheless, going to the Supreme Court, under the circumstances of this case where a resolution of an important question with utmost speed is needed, is exactly the correct remedy as the court has recognized.
But Underwood was really just purely a question of law. Here it appears there are some factual questions that may not be resolved entirely to the court's satisfaction.
Well, Your Honor, I could agree with the court if the respondents had legitimately raised a single factual concern. All they have raised is a matter of law, and that is when did Ms. Ruth's term actually begin? Is it at the swearing in or is it at the appointment? And I think their argument, as Mr. Lujan will address, is frivolous. Other than that, they do not contest that Mr. Mesa and Mr. Cruz were plainly termed out, and they have not brought any suggestion forward that there were in fact duly passed resolutions by the parties supporting the nominations of any of the 6 commissioners who should have been supported by duly passed resolutions. There is no factual dispute. If they had presented a factual dispute, we would then move to the question of how do we resolve it. There is none. This court has before it a record that is uncontradicted that every single one of the members of the commission is not legitimately appointed and not legitimately serving its term. The question becomes, what does this court do about it? I don't know if the court is, obviously I'm going to have to move more quickly than I intended, but I don't know how interested the court is in the matter of laches, but let me say that this matter, first of all, laches is an equitable doctrine, and it is developed in response to equitable considerations. What it requires is 2 things. One, that there is an unreasonable delay in the assertion of a claim. And 2, that there is prejudice to the other side. Neither of those things is true here. The respondents raised the issue of laches, and it's not clear whether they're saying this should have been raised before the election or it should have been raised after the election, but earlier. The short answer is no one knew of the fundamental disregard for the law that was rampant in the GEC. No one knew about it until it was revealed in the press on December 14th. When that occurred, the petitioners moved with all deliberate speed, and within 1 week had completed their investigation, learned of the pervasiveness of the problem, and presented a petition to this court.